Hello again. My name is Anna Troichansky, and I'm an associate with Feldstein Family Law Group. Today, I would like to speak to you about child support in the context of a shared residency arrangement. A shared residency arrangement is when a child spends more or less equal time living with each parent. Monthly child support payments are based on the amount of time each parent spends with the children, the income of the payor, and the number of children. Generally, child support payments are calculated pursuant to the Federal Child Support Guidelines, also known as the table amount, based on the support table that specifies the amount of support to be paid in light of the parent's income and the number of children. In this case, the parent with whom the child primarily resides is entitled to receive child support from the other parent pursuant to the table amount. In the event of a shared residency arrangement, where the child spends more than 40% of the time with one parent and less than 60% of the time with the other, support payments based on the standard federal child support guidelines may not be applicable. In these circumstances, child support would still be required, but may be based on a set-off approach pursuant to Section 9 of the Child Support Guidelines. The set-off approach is still subject to the court's approval, and it is outlined in the Supreme Court of Canada decision of Contino and Leonelli-Contino, where the court set out the test for determining child support in cases when the child or children reside equally with both parents. The factors considered by the court are outlined in Section 9 of the Child Support Guidelines and include the following: the amount set out in the applicable tables for each of the spouses, the increased costs of shared custody arrangements, and the conditions, means, needs, and other circumstances of each spouse and of any child for whom support is sought. Essentially, Section 9 in the Contino case tells us that it is not enough to simply determine each party's child support obligations and set one off against the other. We must take into consideration all factors, including the increased cost of shared custody and the conditions, means, needs, and other circumstances of each spouse and the children. Accordingly, in cases where there is a significant disparity in income between the spouses, the court may look at Section 9(c) and determine that the set-off approach would not be appropriate when considering the means of one spouse to pay more than the set-off amount of child support, the needs of the recipient spouse and the children to ensure that the children's expenses are met, and other circumstances. If the set-off approach is applicable, the parent with the higher income would pay the difference in the table amount to the parent with the lower income. For example, if parent A is obliged to pay $1,200 per month in child support pursuant to the child support guidelines, and parent B is obliged to pay $800 per month in child support pursuant to the child support guidelines, then parent A would pay parent B $400 as a set-off in child support per month, rather than the full $1,200 as set out by the applicable table. If you would like more information about parentage and your obligations or entitlement to child support, please contact us in order to book a consultation with one of our lawyers at 905-415-1636, or you can visit us at www.separation.ca. Thank you.